Welcome to today's Federalist Society virtual event. Today is Tuesday, April 9th, and today we will be discussing Murthy and NetChoice, Speech and Coercion in the Digital Age. I'm Alita Cass, Vice President for Strategic Initiatives at the Federalist Society and Director of the Freedom of Thought Project, an initiative addressing new challenges and questions involving freedoms of thought, conscience, and expression. Today's program will serve as a bit of a follow-up to the webinar we held the day after the NetChoice arguments at the Supreme Court. Those arguments addressed the roles that states can play in protecting platform users' speech. And now today, following the Murthy and Vullo arguments, we will have a chance to consider how that analysis might change when the federal government gets involved. I am delighted to have Todd Zawicki with us to moderate this discussion. Professor Todd Zawicki is the George Mason University Foundation Professor of Law at Scalia Law School and former Executive Director of the George Mason University Law and Economics Center. As always, please note that all expressions of opinion offered today are those of the experts on today's program. We encourage audience participation. Please submit questions for our panelists through the Q&A feature at the bottom of your screen. Please also mark your calendars and note that our upcoming Freedom of Thought conference will be held June 20th this summer. The theme of this conference will be corporate rights and individual liberties. Thanks again for joining us. With that, Todd, the floor is yours.
Thanks, Alita, and thanks. I'm going to briefly introduce our speakers in the order in which I'll ask them to speak. Our first speaker will be Julia Mahoney, who is the John S. Battle Professor of Law and the Joseph C. Carter Jr. Research Professor of Law at University of Virginia Law School, my alma mater. Then we're going to hear from Alan Gura, who is the Vice President for Litigation at the Institute for Free Speech, and filed an amicus brief in these cases. And then finally, Matt Stoller, who is the Director of Research at the American Liberties Project, the American Economic Liberties Institute. And they have very different perspectives on all these. But what knits these questions together, as Alita said at the outset, is we can see this as, to some extent, a trilogy of cases, at least, perhaps what would be a quadrilogy if you include the Chevron case earlier in the fall. But starting with the NetChoice case, which was argued earlier, which dealt with the ability of states to regulate under common carrier policies. Then we have the NRA versus Vullo case, which involves the use of sort of soft but relatively formal, in some sense, the government action, in this case, guidance statements by state regulators. And then we'll talk about the Missouri versus Murthy case, which is sort of even less formal questions of the government essentially pressuring, or what is said has been jawboning, entities that are not directly related, as the financial institutions were in NRA versus Vullo. But nevertheless, there appears to be a very strong effort by the government to influence their behavior, perhaps with either thinly veiled or not so thinly veiled threats of consequences as if they don't do what the government says. So we could think of all these as being on a continuum. And one question I know that Julia Mahoney has given a lot of thought to, and why I want to ask her to kick this off is, well, one of the questions that lurks in the background of these cases is First Amendment, right? And traditionally, one of the threshold criteria for the First Amendment is whether state action is involved as opposed to non-state action. And so what we get here is clearly a situation where it's the government just squarely censors speech, then that would be clearly unconstitutional. But what we see here is something different from that. I'll let Julia talk about the extent to which it's different or it's similar. And then, question of whether or not the government is specifically going right up to the line. What are the limits on the government being able to do that? And when does it become sort of this magical incident of state action? So, Julie, I'll ask you to give us a sense of these cases, maybe orient us a little bit to what the issues are, and then give us your reflections on what you've seen and heard in the cases.
Thank you, Todd, and thanks to the Federalist Society for organizing this event and also for including me. These cases that we are focusing on today, the so-called jawboning cases, Murthy v. Missouri and NRA v. Vullo, argued before the Supreme Court in March, as well as the NetChoice cases about state-mandated access to major social media platforms, have in effect emphasized, not that anyone didn't understand this before, just what doctrinal messes both state action and the First Amendment are. So Todd is absolutely right. Standard statements about censorship are that the government censors, but private parties are not engaged in quote unquote censorship. Private parties are not the government, and the Constitution, with limited exceptions, constrains government, not private power. Of course, we are now in an era where there are understandable and profound anxieties about concentrations of public and private power. We know a lot now, thanks in part to the so-called Twitter files, about what its detractors call the censorship industrial complex, whereby government and private entities, powerful business entities, work together in tandem in order to de-amplify or even silence heterodox views. But one big problem we have is that state action doctrine has never been able to address these issues terribly well. There are a few outlier cases, most famously perhaps Shelley v. Kramer, about whether or not a court's decision to enforce a restrictive covenant constitutes state action. 1940s case, the Supreme Court answers yes, but that one is a real head scratcher. How can a government enforcement of a privately negotiated covenant on real estate constitute state action? Many would argue that the state action in play in Shelley v. Kramer was the fact that the state was in effect establishing and maintaining a brutal regime of racial segregation. But if that explains the idea of state action in Shelley v. Kramer, it's not what the Supreme Court said. Turning to the First Amendment, we have additional doctrinal disarray. The Knight Center for the First Amendment at Columbia did an excellent job of surveying the various arguments put forth in Murthy and Vullo and explaining just how difficult the doctrine is to make sense of in this area. The court has how do we draw the line between persuasion and coercion? Is really coercion the standard? Is this a problem only when the government is actually engaged in coercing entities to de-amplify or shut up private heterodox views? We just don't know. During oral argument, it seemed to me anyway, the justices were trying very hard to get the oral advocates to give them at least some ideas about how to draw these lines. But I think it's fair to say that as yet, even the most skilled oral advocates before the court have not been able to throw the justices much of a lifeline.
Thank you, Julia, for framing that up for us. Alan, I'd like to turn for you to talk about sort of some of the background principles. Julia talked at the end there about the line drawing problem. And, when I look at the law here, it looks like, but first, these cases seem kind of unprecedented, right? One of the things that's quite fascinating to me is that a lot of this has just been that in the past, I think the government just understood there's things that just weren't right to do, right? To abuse their power in ways to infringe on people's free speech rights. There was a sense of self-restraint that no longer seems to exist anymore. And so now we basically are in this realm where it seems like relatively unprecedented behavior. And the doctrine, goes back. There's some older cases, like, we know from the Norwood versus Harrison case from '73, for example, a state may not induce, encourage, or promote private persons to accomplish what is constitutionally forbidden from doing directly, right? And so what we see now is these questions about, as Julia said, coercion, persuasion, sort of encouragement, significant encouragement. How should we think about this, and how do we think about sort of the discretion that this gives to the government, and maybe thinking about these line drawing questions that Julia put before us?
Sure. Well, the question I think that a lot of people are wrestling with, especially after listening to the justices' questions, is could we possibly see an outcome here in these cases based on the questioning? Predictions are imperfect, but could we see an outcome where New York is not allowed to pressure banks and insurers to cut off the NRA just because it doesn't like that group's advocacy, while the federal government somehow gets away with pressuring social media companies to censor the speech it doesn't like? And sadly, I think that we might well see something like that come about. We could see that situation arise. That would not be my preference. I believe the government should lose both of those cases. The justices, however, may fundamentally misunderstand the nature of online speech and the key to understanding this problem that the justices may be experiencing. Could be seen in their approach to the NetChoice cases. Now, obviously, as Julia mentioned, and as you mentioned, Todd, if the government can't legally do something, it can't evade that illegality by asking somebody else to do it on its behalf. And also the First Amendment prohibits viewpoint discrimination. So the government can't censor or burden speech just because it disagrees with the viewpoint that's being expressed, and it can't punish the speakers for saying things that the government doesn't like. Now, under those concepts and that precedent, I think the NRA case is actually probably the easiest one here. You had New York regulators and even the governor engage in outrageous speech, threats, guidance letters, actions that were taken to coerce banks and insurance companies for to cut their business with the NRA, explicitly because the governor simply didn't like the NRA's point of view. It culminated with a series of tweets even after the case was filed, where Governor Cuomo stated that we're forcing NRA into financial jeopardy. We won't stop until we shut them down. If I could have put the NRA out of business, I would have done it 20 years ago. That should be an easy case where insurers, banks, other people that the organization needs to survive are abandoning it because they can't handle the regulatory repercussions of servicing this controversial client. But in Murthy, the questions were very different, and there were a lot of questions that seemed to suggest that what the government was doing with social media was merely persuading, merely giving feedback, that the vast embedded network of government control and feedback over, not control, basically almost control of censorship decisions online was just a matter of criticism, not unlike a press officer perhaps yelling at a reporter or a newspaper editor that they got a story wrong, right? There's nothing wrong with the government trying to persuade speakers to change their mind. The government could, if it wants, call up the NRA and say, hey, how about you stop advocating for gun rights? And the NRA would probably say, no thanks, and that would be that. But the government can try. No harm in that. That doesn't violate the First Amendment. And likewise, the government can critique reporting. It can critique an editorial. It doesn't have a right to speak, but it has a power to speak. The government couldn't function if it were unable to speak. So it can present its point of view. The problem, though, is that Facebook and X, if we call it that these days, are not like newspapers. This is the concept that the court stumbled over in the NetChoice argument. The NetChoice case involved platforms asserting that they had a First Amendment right to deplatform, censor, demonetize, shadow ban, whatever they want to do. They could control the speech on their platforms because they were basically acting in an editorial function. They thought that they were newspaper editors or parade organizers, and so they had a First Amendment right to control the speech that they put out. It seems like some of that may have seeped into the justice's understanding of online speech. So now in Murthy, when the government wants Facebook or X to censor Professor Zwicky or Matt Stoller, well, you know, they're not really censoring Zwicky or Stoller or Mahoney. They're just persuading Facebook to change its speech. So whose speech is it? That's the central question in NetChoice. And that's the question that if they get NetChoice wrong, they're also going to probably get it wrong in Murthy. This is not a welcome outcome for people who value the ability to express themselves online, to engage in civic society, and to use these platforms the way that we use them today. These platforms do fulfill a certain role in our society, and they are not newspapers. Let's face it, they do not review the overwhelming majority, or in fact, any of the speech that people constantly post online. They're not engaging in any editorial function. They're basically conduits for the speech of others. They are much closer to the phone company, the telegraph from the olden days, and other common carriers or businesses that simply are detached from the speech or product that they carry. We do see that line of thought expressed by the platforms whenever somebody tries to hold them responsible for the speech that appears online, right? So a couple of years ago in Taamneh v. Twitter, Twitter v. Taamneh, the Supreme Court said, hey, the platforms are not responsible for the ISIS speech, the terrorist recruitment that's going online. That's their users' speech. They had nothing to do with it. They're just putting up a platform and anybody can come by and say what they want. And they don't own the responsibility for that speech. But now when the platforms want to change the discourse and control what is said in their platforms, and suddenly they're newspaper editors. They want to have it both ways. They want to be both newspaper editors when they want to restrict speech, and they want to be basically conduits, empty vessels, when somebody wants to hold them responsible for the speech they carry. How long that sort of dual existence, that sort of schizophrenic Schrodinger's cat situation can remain, I don't know. But it's hard to reconcile a conception of online speech as being the platform's speech with the idea that, maybe anything bad happened in Murthy. I think that that's not the way that the court should approach it, though. There is a role for states to try to protect consumers against censorship by these platforms, and also as posited by the question that was posed in the blurb announcing this forum. There is a role for the states to play when they try to protect online speech, to push back against this sort of jawboning by governments, right? It would be nice if the platforms could go back to the government, whether it's our government or somebody else's government, and say, listen, we understand you want us to take down this speech, but we also would like to operate in Texas and Florida or these other states, and it would be unlawful for us to engage in viewpoint discrimination and restrict those consumers in their expression. So it could stiffen the spine. These laws that Texas and Florida and other states are considering, could help with the problem that we've seen in Murthy. But first, I think I hope that Murthy comes out a little bit better than the argument predicted.
Thanks, Al. And I want to turn to you, Matt, because you've had a very interesting perspective on this for a long time that you must be sort of feeling a bit vindicated by everything that's come out about threats of concentration and the impact that it can have on values beyond, I mean, obviously talk about economic values, but values beyond just economics in society. And Julia mentioned concentration in her remarks, and Justice Gorsuch specifically asked that question early on in the Murthy case. Should it matter that these industries are so concentrated? And obviously he was grasping at something, or he was asking a question where he already knew the answer and was and framing it in the form of a question. I guess we'll find out later what exactly it was. But to ask, I'll ask you the question that Justice Gorsuch asked the lawyers: should it matter that these industries are so concentrated, and if so, why? And in particular, is a sort of beyond the economic questions of competition. Why does it matter, do you think, in your mind, that these are such concentrated industries and the effect it might have on values beyond just economics?
Yeah, thank you so much for inviting me. Yeah, I do. With all like the private coercion and censorship going on, I feel vindicated. Makes me, I feel with all the creeping sense of there's nothing you can do about any of the problems we have. You can't even speak. It warms my heart, because I was like, I was right. All right, so it's a great question, and there's not an easy answer, but I would sort of start. I'm going to start with my like kind of trolley type of observations about the First Amendment and the history of the First Amendment. I'm not a constitutional scholar or a lawyer or anything like that. I write about monopoly power, but I would say I think in our modern discourse around the around free expression, we think too much about the First Amendment as a form of prohibiting what the government can do, and not enough about as the broader responsibility that the government has to, in terms of network design, to craft a society that can engage in free expression. So the First Amendment doesn't actually say the government can't prohibit expression. It says Congress, right? It's not about the executive branch, it's Congress. It also has the prohibition on state religions, but in fact, very early on, there were states that had religions because it said Congress. And so the interpretation that this applies to the federal government is not something that we have, or that this applies to the executive branch. The federal government is relatively new, and it's also not complete. You see, the entire national security establishment has clearances. And what is that if not a prohibition on speech, right, by the 3 or 4 million people that have access to classified information? And that's not to say that they shouldn't have that prohibition. It's just to say that it's all pretty arbitrary. We just sort of ignore the parts of the free speech that we're not allowed to engage in, and adhere to a myth that a largely mid-20th century model of the First Amendment is the way it has always been. I would also point out that under sort of the NetChoice view of the world, in which the First Amendment is kind of wholly expansive, insurance companies and banks and electric utilities, all of them would have a First Amendment right to deny service to the NRA or to any group that they felt that they don't wish to serve. And this is really, I don't think there's any grounds to see the First Amendment stretching over that. But to your question, which is about the consolidation, the concentration of these industries, which is something that the Justice Gorsuch noted, it is a if you think about free expression as a design principle, First Amendment as a design principle, then you have to look at how do we speak today? And we speak today through a relatively small number of dominant tech platforms. And that means that it is, the government has to put in And I'm not talking about just the federal government or state governments, but any governing power has to put in relatively little effort to shape speech, because they only have to get a few people in Silicon Valley to go along with what they want. And that is historically unusual in America. We've never allowed that kind of consolidation of power, particularly over information, but really over anything. It's also a global problem. It's not just in the US, although the First Amendment obviously only applies in the US. And what was interesting about, I think, both the NetChoice and the Murthy case is that concentration did come up, and it kind of went both ways, because when Gorsuch asked the question, well, doesn't this make censorship easier if there's concentration? One of the responses was, no, actually it makes it harder. If you're a more powerful company, you can stand up to the government versus a less powerful company. So you could see it in both ways, but in general, if you have significant amounts, I'm going to bet on 1,000 small companies have some of those people standing up to the government than one large company, or just a few large company that have significant equities in front of the federal government that they're trying to get, or they're trying to access. So I'd also note one other observation about one of the precedents that came up in the Murthy case, which is the Bantam, which is about the Bantam case around state action in Rhode Island. And they said, well, when you have the government censoring books by telling private distributors that they can't distribute these books, or else the police will be notified, that even though it's indirect, it's still state action. One of the core ways that they actually executed the censorship was through a monopoly distributor. So the distributor of books in Rhode Island was the only book distributor. And so that all the state council had to do was just tell that one distributor, don't distribute here's a list of books we would encourage you not to distribute. And so there's always been this intense relationship between market power and the ability to have free expression. And that makes sense. I mean, you just have one bridge that you can go across to transport an idea. All you got to do is have someone on that bridge to stop it. A couple of other points about the cases. This is not just a conservative concern. I think you saw the relationship between censorship and concentration. You saw fear on the left when the Trump administration brought a case against AT&T buying Time Warner, because there was fear that Trump was trying to use his power to influence CNN. And you also saw it recently when the Federal Trade Commission chair, Alina Khan, went on a television show with Jon Stewart, The Daily Show, and Jon Stewart said, when I worked for Apple, I wasn't allowed to interview Alina Khan. They asked me not to. I wasn't allowed to talk about AI either. So you do see this kind of popping up all over the place. Typically, the censorship concentration debate is considered a conservative point of view, but it isn't. The last piece I would say is that when you're reading when I was reading the Murthy case, there was a significant amount of concern about coercion, and that coercion came down to basically two things. One was Section 230. We're going to repeal, or we're going to do something to Section 230 if you don't shape speech the way that we would prefer. But that, of course, requires Congress to act. So it's not totally clear that the executive branch could do that much about it without Congress acting, and they haven't, even though the Trump administration and the Biden administration were both opposed, or say they were opposed to Section 230. The one area where I think everybody acknowledges that there was a potential threat is antitrust. So if you don't do shape speech the way that we prefer, then we are going to bring an antitrust case against you. And again, this is not just a conservatives being concerned. Under the Trump administration, there was a use of antitrust to address California pollution rules, marijuana, a bunch of other things that the left cared about. And so it seems to me that is a potential area where, historically, you've seen the use of antitrust as a lever for the president in terms of cronyism. That's always been something that's a danger. And so it does seem like putting some thought into how to dull that and to make sure that it can't be used that way makes sense. We could go into sort of discourse around that. There's, I think, been an attempt to do that by situating it in the realm of economics, which I don't think is I don't think that's worked for a variety of reasons, but it is worth thinking about how do you dull the ability of the executive to use antitrust in coercive ways while sharpening it to address concentration. So there's sort of a thin line that you need to tackle. And then I know I already said the last point I wanted to make, but I will say it again, and with a slightly different point, which is one of the, I think, big questions that we're seeing about government coercion in speech is because of the global nature of modern technology. You also have to ask which government, as we're seeing with TikTok and with a whole suite of activities. The US government is not the only one playing in this arena, trying to encourage and shape speech domestically. The Chinese government is doing it. Many governments are doing it, but other governments have coercive levers as well. So to the extent that you defang the US government, you also have to think, does that undermine the ability of the US government to protect against foreign governments that might use coercive techniques? So all of this is to say that the question of concentration, the question of market power, I don't think it can be divorced from the question of free expression. There aren't any simple answers here. And I think that's because we have such a consolidated communications apparatus. I don't think we're going to be able to solve these problems because I just don't think the questions are answerable as long as just a few people control the infrastructure for speech.
I believe it was Judge Don Willett in the Fifth Circuit oral argument who framed up the whole issue, talking about antitrust 230, like is nice little social media company you got here. It'd be a shame if something happened to it, kind of sense. And that segues into the question. I want to come back to you, Julia, since you, like me, are kind of very familiar with the realities of the regulatory state and how the regulatory state operates in many ways. Wayne Cruz at the Competitive Enterprises who calls it regulatory dark matter, that so many of the ways that the government operates these days is through concepts like reputation risk, through guidance, as we saw in NRA versus Vullo, which is, of course, what the Obama administration used 10 years ago through Operation Choke Point, the concept of reputation risk. And so, I have two questions that kind of go back to sort of teasing out some of these ideas of state action, which is in the world of the regulatory state, when it seems very unrealistic to me, at least in some industries, maybe along the continuum, to say that when the government suggests something, everybody understands that a suggestion is not just a suggestion. When you're a bank and you understand there's so much discretionary power that your regulator has over your for a bank or an insurance company, a lot of bankers and insurance companies are afraid to even bring lawsuits, and they tell stories about their regulators basically saying, through guidance, you really don't want to do that, right? You really want to bring that lawsuit. You don't want to take a public position on that. So my first question relates to sort of what is coercion? What is significant incursion? What do all these words, they even mean anything in the world of the regulatory state, where so much is just regulation by raised eyebrow, where the government has so much discretionary authority? And the second question I heard in the oral argument that relates to state actions, a lot of the justices, you talk about the line drawing problem, they seem to really be grappling for, I think, really kind of a degree of tracing causation that's just simply not realistic, right? And essentially could never be proven in a given case. Or I believe it was Justice Alito said, unless the government's incredibly ham-handed and ham-fisted about how they tell you to shut somebody up, kind of like as they did with Alex Berenson, and you could draw a direct line between a communication and an action, you're not going to be able to make a case. And it sure seems like that is a very high burden for somebody to have to show causation with that degree of connection to establish state action and in what seems to be the reality of what's going on a lot of times.
So as to your first question, could we craft a doctrine whereby we would have a better idea of what constitutes coercion, what constitutes mere persuasion, what constitutes government providing valuable information in an efficient way to private parties who might need it? Sure, I think case by case, we could build out such a doctrine. Would it be perfect? Absolutely not. But I think it would be at least helpful. We can also consider proposals, including some from the Foundation for Individual Rights and Expression, to make for more transparency. For example, to require disclosure of government contacts with big social media companies. There are obviously some downsides there, but I think there could be some significant upsides. It is at least something that is worth considering. We don't want to set up a society whereby the government cannot alert its citizens, alert and social media companies and others to clear and present dangers. Of course, no one is at all suggesting that the government should not be able to do that. But there are these concerns that if government actors get too worried that they'll be deemed to be coercive or bullying or jawboning or something along those lines, that incentives being what they are for bureaucrats, that some government actors might well stand back and not do their jobs properly. And I think we cannot dismiss those concerns out of hand. As for the difficulty of redressability and traceability that was expressed in the Murthy arguments, that is an effect of the Supreme Court's own standing doctrine. And standing doctrine is another area where we have a mess. Standing doctrine is an amalgam of constitutional doctrine. Sometimes the court says that certain limitations on standing rules about standing are mandated by their interpretation and construction of the Constitution. Sometimes standing rules are said to be prudential, a matter of measured judgments by the judiciary about institutional competence and resources. But right now, there is a lot of emphasis on these concepts of whether an injury is traceable to the complaint about conduct, and whether or not, even if an injury is traceable, whether or not courts can do something about it, whether it's redressable. As Todd points out, that means that many instances where there has been what we might call jawboning, or even stuff that borders on coercion on the part of the government, is not going to be something that courts will say that they can do anything about, because how can you know whether or not this particular behavior was actually the cause of someone being removed from Twitter or de-emphasized on Facebook or whatever it is that happened. So going forward, it's clear that where the facts are simple, as in the NRA case, and the fact that a government worker went beyond what just about any reasonable person would think was warranted in executing her duties, then there's going to be a strong case. But as Todd points out, the set of those cases is not going to be all that large. So this brings us back to, if the redressability and traceability are going to pose such formidable barriers, and I think they are huge hurdles right now, what can we look to? We can, of course, as always, look to modifying the doctrine of standing. And there's a lot of interesting academic work going on in that area right now. But I don't see anything, frankly, on the horizon that is likely to be adopted that would do very much except nibble around the edges of the problems that Todd just described. So right now, I am at least thinking more about transparency, such that there could be government disclosure of government contacts, about having ways to get at that information in real time. Obviously, we have FOIA and we have discovery and lawsuits, but both of those are quite cumbersome. Perhaps we could craft some kind of way for information about what government contacts, what the government contacts have been, so as to, in effect, have more sunlight, which we are told, of course, often is the best disinfectant.
And you make an interesting point, Julia, which is, one interesting thing about this case is there was similar case filed earlier, I believe, in Ohio. But what's significant about this case is all this information that came out in Murthy versus Missouri, as I understand, only came out because the judge in that case ordered discovery, and didn't just dismiss the case out of hand, or we wouldn't have known about any of this sort of stuff. And I believe it was Judge Willett again who made the observation of the Fifth Circuit that it's sort of a funny thing for the government to be arguing we want to be able to express our opinions and speak, but only in private without telling anybody that that we're telling, we're talking to these companies totally secretly, right? And that's how our First Amendment operates here. So, Alan, you made some remarks I wanted to come back to, and Julia referred to this and about the role of the government being able to speak, and the justices obviously being concerned about that, particularly Kagan, Kavanaugh, Jackson, right, who expressed concern about we don't want to hamstring the government from speaking in times of a crisis like this. But there were two things that struck me as I listened to the oral argument, and I'd be interested in your responses. The first is, it struck me that several of the justices were much more concerned about suppressing the government's speech than the possibility that the government is suppressing other people's speech. It's like, I get that there's a line drawing problem here, but it seems like the line drawing problem we traditionally have would be about government doing things that chills individuals from being able to speak and express their opinions and that sort of thing, not sort of putting all the weight on the scale of the government being able to express the opinion. And of course, the opinion here was not, our opinion is Zwicky is wrong. Our opinion is that you should prevent Zwicky from speaking. Strikes me as a very different kind of statement. And then following up on that, tell me, it struck me as I listened to the state arguing the case. He said, to respond to the thing, well, the government needs to be able to speak. He said, yeah, that's why we have strict scrutiny, right? Which is, all it says is the government would just have to show they got a really good reason to do this in a time of emergency or, something like that, but not sort of vague concerns about information floating around out there. Not be able to, suppress information about where American troops are, that they're about to invade, France in World War II. But that's a lot different from taking down Zwicky's video where I'm talking about my lawsuit against the COVID mandate.
Yeah, well, we may have reached the limits of doctrine, right? We can make all these rules and balancing tests and announce different levels of scrutiny. But at the end of the day, if the judiciary is comprised primarily of people with a long record of government service, prosecutors, people who have a cultural intuition that, well, the government wants what's best for everyone, and they're more comfortable in that role there as opposed to the role of some perhaps eccentric scientist or law professor or somebody with an opinion, then you see that comfort level with the government seep into interpreting the line between persuasion and coercion in a very different way than other people with a perhaps more practical business experience as to how things work out there when you're dealing with regulators and other friends from the bureaucracy. And this goes back to, I think, a point that Matt made. Powerful companies, I agree with Matt. If you have a handful of companies that are operating a space, likely they are going to be from the same cultural milieu as the people who regulate them. There's going to be a revolving door between the regulators and the regulated, and that's just the way the world works. And there's not going to be a whole lot of friction in between them. And what happens if they all agree with each other, right? I mean, perhaps the biggest threat to free speech is not from the government jawboning or trying to coerce an unwilling platform that doesn't want to censor its users. It's, I think, some of maybe what we've seen here, which is platforms that are quite all right with the censorship because the censorship the government would like to see happen accords with their cultural and policy priors. You do see sometimes perhaps one eccentric zillionaire, an Elon Musk come about, and maybe he likes fighting with the government and he's more liable to stand up. But the reality is that most business leaders are not interested in fighting with regulators. They'd like to have a nice relationship with regulators. They probably see the world in a very similar way. And so without the law interceding here and empowering the users in some sense, there may not be a whole lot of hope for online freedom. So I don't know what we can do. We can definitely say, yes, it's strict scrutiny, is very strict. But what if everything is compelling? We saw a version of this, not to go off topic, but in now decades of litigation over the Second Amendment, right? We've had a fundamental right to keep and bear arms. It means absolutely nothing for the fifth of the population that lives in the Ninth Circuit, because every case will go en banc, right? And they will always find a reason to defer. And the courts try to fix that with another NRA case of Bruin, but we're still seeing resistance. And likewise here, it's persuasion, it's okay. They're just talking. If that's how the judges see the world, I'm not sure what different tests can do for you. The one thing that can do something for you is a recognition that the speakers online are the users, not the platforms. And then it looks totally different. It's no longer the government having a conversation with its friends in the editor's room. It's the government telling a third party to silence an individual. And that is something that hopefully would have more purchase here. Sorry.
Can I ask a question about that particular, because I agree with that, pretty much everything that you said. But I'm sort of the token lefty here. So I'm not saddled with the immense skepticism of the administrative state that you guys have. I mean, I'm very skeptical of the administrative state, but I can embrace it when I want to. When you talk about having a small number, the government and their friends at the platforms, and that being a significant problem, we have to make sure that there are checks there. Presumably, it's some form of common carriage rulemaking or public utility rulemaking, like what Florida or Texas did, no viewpoint discrimination. But what kind of administrative state do you need to support something like that? And then how do you prevent an administrative apparatus from sort of capturing that process, right? I mean, I can think of administrative states that would look fine and that would work, but I just could have put it to you. How do you build an administrative state to ensure free expression if the problem is the administrative state fused with tech platforms in the first place?
Well, you eliminate the administrative state. I don't think you build an administrative state. I don't think that having an administrative state that's removed from the voters, that's removed from any practical accountability, is going to somehow guarantee lots and lots of freedom for everybody. I'm not sure.
But somebody has to enforce the laws saying you can't. Point discrimination. So how does that?
There is a role. There's a role for other people to enforce the law, namely, lawyers, right? The Attorney General of the state can take action to enforce consumer protection laws without a massive administrative apparatus. If somebody complains that they have been deplatformed and censored, or they've not been given their data as required by state law, there's room for an enforcement action. And also the private bar may have a role to play in this. I don't necessarily know why you need lots and lots of government employers and bureaucracy to make sure that people can speak freely. That seems counterintuitive, and I'm not sure that's necessary. And I would hope that if the Texas law, for example, were to be upheld, and it came to be that Facebook and X just had to deal with it, then maybe they would obey it. Maybe the juice wouldn't be worth the squeeze, right? They wouldn't try to somehow sneak in and censor people based on viewpoint.
So you're saying do it through the courts?
Look, rights are typically enforced through the courts. Look, we need to have. I'm not an anarchist, right? We need to have some way of enforcing people's rights. We have to have courts to enforce contracts. We have to have some mechanism where bad actors or people who flout the law are brought to account and respect the rights of others in society. And I don't think the administrative state has necessarily done a great job of that. I think we should have fewer rules, clear rules, simple rules. Like,
I think that's right.
no,
Yeah.
we don't have an administrative state that enforces the First Amendment's prohibition on viewpoint discrimination. We have organizations such as mine that go out and sue the people who engage in viewpoint discrimination. And we do that a lot, and that seems to work. I don't think we need to have a Bureau of Viewpoint Enforcement that's going to govern city councils and school boards and the like. So we've had some experience in regulating viewpoint discrimination through the courts.
Matt, I want to, since you self-identified yourself as the token, what do you call yourself, the token lefty
That's
on
right.
the panel, you said a couple things at the beginning that struck me, and I think the listeners would be interested, is the two things that are very striking me, which is first, you mentioned a few groups on the left who are concerned about this, but this seems to be a lot less of a concern among those on the left, which is kind of striking because you would think that the prospect of Donald Trump in a Trump administration leaning on social media companies with respect to things like information about trans rights and women in sports, that sort of thing. And so my first question is, what is your perception about sort of how people on the left think about this? Obviously, there's a big disagreement among conservatives, even on the question of the regulatory state you were talking about. And the second thing that's struck me is you mentioned the impact on standing abroad and foreign standing abroad, which is this is going on in Brazil right now. But there was a big kerfuffle about Vladimir Putin censoring what people could say on social media about the Ukrainian war. And the Ukrainian war wasn't going very well and that sort of thing. But basically, his response was, well, I'm allowed to suppress misinformation. The war's going great. Who are you to say the war's not going great? And of course, in this case, one of the points they made in lower courts was what was being suppressed here was not misinformation. It was true information about, or potentially true information about the lab leak theory of COVID, whether COVID vaccines prevented infection transmission, all that sort of stuff. It seems like kind of once you go down that path, you do have this problem. If the government gets to define what's misinformation, then, it seems like they can define just about anything as misinformation, whether foreign or domestic.
I forgot the first part of your question.
The first part was about sort of on the left, sort of
Okay,
how sort of progressives, what are kind of the debates in progressive circles? And you mentioned some are concerned about this, but a lot don't seem, none of the justices, 3 Democratic justices on the Supreme Court, for example, seem very concerned about abuse of the government being able to suppress speech and that sort of thing.
Right.
And why that might be.
So I mean, I think there are different parts of the left, and I think there is a generally concern about concentration and free expression, which you can see in I think about antitrust a lot, but you saw there was a merger of or an attempted merger of Penguin, Random House, and Simon & Schuster, two of the big 5 publishers, and the antitrust division, which is sort of considered one of the more populist parts of the Biden administration, challenged it and said, this is going to reduce the amount that is paid to authors, which is a kind of a worker labor centered view, but a legitimate view of antitrust and competition, but also that it would reduce the diversity of thought carried in books, because then you would have one fewer bidder for ideas that get turned into books. I think books carry a certain weight in terms of ideas. And then they won that case, and it was a Democratic appointed judge who ruled on it, Florence Pan, who's now on the circuit court. So, then you've also seen, I think, the recent filing of the Apple antitrust suit, where the antitrust division said, look, Apple is not just a alleged monopolist in the smartphone market. They also are a big movie producer, and they can exert control over the flow of information. And so you've seen, so I think it's the debate, the argument that would be more skeptical of concentrations of power is coming through the competition policy people who are generally concerned about coercion through private actors. But there is, of course, there are elements of erecting barriers to entry through government regulation, things like that. I mean, that's something you see all the time. And so the people that are dealing with market structure see that. On the other side, I mean, there's a, there is a, and you saw substantial amounts of support, I think, for antitrust, stronger antitrust law within the Democratic caucus on the House and the Senate. So there was a fear of concentration of power there. On the other side, you saw, I think, a fear of disinformation and a desire for content moderation to mediate hate speech. And that comes from the kind of more kind of cultural progressive side of the Democratic Party. And they don't directly argue very often, which is why it's kind of hard to interpret the factions. I think if you're just sitting from the outside, you might say, oh, they all agree. But there is a deep tension there, and there are flashpoints where you can see that debate happening. In terms of the, I think you will see it if Trump wins again, you will, I think, see that flashpoint come out, again, like I supported the AT&T Time Warner case, but there were a lot of people who said, no, this is just Trump being a tyrant or whatever it was. And I think you're going to do that more and more. Now I've forgotten the second question that you asked. So I forget.
The second question was about, you made the interesting point about foreign governments. And I gave the example of Putin said, I'm not engaging in censorship. I'm just suppressing misinformation. The Ukraine war is going great.
So what is our, I mean, that's another country. Are you?
Yeah, no, I think, I mean, this concern about the idea of our inability to sort of show moral leadership on other countries. I just thought was a striking, if the government here is suppressing speech, it does seem like you raised a point I hadn't thought about before, which was the ability to influence foreign countries who are basically saying the same thing. So
yeah, I think what you do, that's right. I mean, I think what you see is that the U.S. The discussions here reverberate everywhere in a way that I think is somewhat unique. And everyone's wrestling with the consolidation of speech platforms, which are largely American with the exception of TikTok. And then in China, they have some of their own. And what do you do about that? And I think that the U.S. is sort of leading the way, not saying in a good or bad way, just that there is a fear of other countries doing anything to American companies that are big and powerful. That is not, we don't have that same fear here. So we are, in many ways, the way we structure our platforms is simply going to structure speech in other countries, whether we like it or not. There was a moment when Mark Zuckerberg just decided to do a test run of how news would flow. And he just picked like 5 small countries and just changed the algorithm just to see how to change the news ecosystem. And that's the level of power that we're dealing with here. So, and then you have the political arguments about disinformation that definitely reverberate, and Putin used it here, or used the same language that we were using. You see these the moral arguments that the U.S. makes about sort of leadership. Other countries kind of adopt that and as they see fit. So I think that's definitely something to consider as we're addressing these policy problems. I would just note that just to sort of put a fine point on it, I am a just to say, sort of suggest something that Alan said. I am a strong believer in public utility laws, common carriage rules to address these kinds of large platforms. I think we have to entertain the possibility that if you were to put a law like the Texas or Florida rule, and do it maybe on a national scale or do it in lots of different states, that you would find the demand for that kind of activity to be really substantial. You'd see a lot of people wanting to take advantage of it for a lot of different reasons, and it would overwhelm the courts. as they are currently constituted. And so you would either have to dramatically enlarge in the courts, and the courts would effectively become an administrative apparatus, or you'd have to find some other way of doing it. So while I'm a big believer in the Anglo-American tradition of private litigation and precedent and whatnot, I do think there is kind of a question of, there's just a size and scale and complexity to a lot of these disputes you're going to have to deal with. And I don't have an answer as to how to do it, but I don't think you can escape it by assuming you can handle it just with this court system.
I want to go around the horn. We're starting to run out of time. I've got sort of general questions for all three of you. It sounds like we're all in agreement that there's a problem here. Then the question becomes a question of solutions. And one of the things that bothers me is I read the tea leaves in NetChoice, and I read the tea leaves in Murthy, as I read the tea leaves in Vullo, and I hope you're right, Julia, but there was this sense in which, for example, Justice Kagan was saying, well, the real problem here is they issued this sidebar communication that will go easy on you if you, on your regulatory problems, if you censor the NRA. But there's really no problem with using sort of reputation risk. That's just what regulators do all the time. And they all kind of, which all kind of adds up to sort of an honors. We'll just put the government on the honor system. And so if you take away common carrier through NetChoice, if you take away the ability of individuals to vindicate First Amendment rights under in Murthy, if you define state action very narrowly in Vullo to say the government has huge discretion as long as they don't engage in that sort of deliberate quid pro quo, and hopefully you're wrong about that. What's left? What tools are left? Is antitrust the only thing that's left? And do you guys think that's the best tool for this, or what other tools might still be left for the government to address what seems to be fairly widespread sense of a problem?
I'd say beefed up disclosure in real time is probably the best solution that could be implemented in a short time. But I did want to pick up on one thing that Matt was saying about the tensions within the left. I think it's very important to understand just how concerned a lot of people, most of them, but not all, so far as I can tell on the left, are about a perceived problem of misinformation. Because I am reading again and again and again in academic literature, and even hearing it from some people I know who are on the left, that it is a big problem that First Amendment doctrine, as currently constituted, makes it hard for government to exclude from public discourse flat-out false claims, particularly those about science and medicine. And what is more, the fact that sometimes these claims that are declared to be flat-out false turn out to have something to them doesn't really seem to make much of an impression on people. So there's this notion I pick up that truth is not a kind of constantly evolving target, but that whether or not something counts as misinformation is at least in substantial part a function of whether experts think it is right or not right now. And that is a very difficult thing to push back against. And picking up again on something, one of the points raised earlier about the complexity of US society. We obviously have a sophisticated society with a complex network of institutions and human connections, and the government is not designed to be in our system, and frankly, cannot be. No government can be the boss of this entire system. And so if we think that one of the crucial responsibilities of the government is to facilitate the functioning of the institutions of civil society, and to ensure that these institutions, together with the knowledge and understanding they produce, will in turn enlighten government, then I think you're right that we do have a huge problem. When we look at government responses to COVID-19, I think in effect, these institutions of civil society were mobilizing to do their jobs, to present a lot of different views, a lot of different ideas.
Yeah.
I think the Great Barrington Declaration, which of course, it turns out with hindsight, made a lot of that actually looked grounded at the time. Very impressive people, of course, formulated it and critiqued some of the government lockdowns and so on and so forth. But the idea that the government needs to learn from institutions of civil society, that there are experts out there who aren't part of the government in particular, that seems to be getting short shrift. And so in thinking about solutions, I'd like very much to try to put those problems front and center.
Alan, what do you think? I mean, one of the things that makes me anxious listening to this, as I said, it sounds like a lot of the justices, and you referred specifically to these, a lot of the justices have very narrow sort of life experiences. They haven't sort of represented clients in the private sector. They see themselves as sort of affiliated with the government in some way, and so there kind of feels like this kind of feeling of an honor system that the government won't abuse this, they won't abuse these powers. But it strikes me, first, that may be unrealistic, but second, where it seems like that leads us to is sort of a tit for tat world, which is the only way it gets fixed is you'll suppress our speech, and when we're in office, we'll suppress your speech for political advantage. And if there's no guardrails around it, what is there to stop sort of descent to the lowest common denominator? As we talked about, I think a lot of it used to seem like it was more self-restrained is what did it in the past. And if we don't want to just have a tit for tat system that turns into the Hatfields and McCoys, and we tie our hands with all these other things, do you see other viable solutions, none of which strike me as necessarily as good as these, whether antitrust, repealing 230, what might you think would be the kind of things we'd be thinking about if these options are taken off the table?
Well, I don't know. I mean, for sure, we need to remember that the First Amendment protects a set of neutral principles, and a lot of people in the last several years have been behaving as though they're never going to lose another election. And this is not a good recipe for stability and civic harmony. The whole point of the First Amendment is to protect the speech that you hate, that you think is offensive, that you might think is dangerous. We don't need the First Amendment to protect the speech that's not controversial, because no one's going to ever go after it. And so it's tempting always for the people who are uncomfortable with the speech that's being suppressed to look for a justification. Well, it's misinformation and somebody might be harmed, and people try to look for reasons why it's okay in this instance to stick it to the other side and to stick it to the speech that I don't like. This is something that everyone just needs to get past and go back to an understanding that we're supposed to be protecting the speech that we don't like. If you don't like it, maybe that's all the more reason why you should allow for it to be disseminated. I don't know how we get the country off this tit for tat business, but as far as repealing 230, the 230 is a good policy, properly understood. I mean, it is abused. There are instances where 230 is invoked to immunize platforms from behavior that is not contemplated by the statute and would not make sense to immunize them for. But I think that there's a political reality, though, which is inescapable, that if the platforms keep insisting that they're newspaper editors and they keep demanding the right to control the viewpoint on their platforms, and at some point there's going to be a lot of political pressure to say, okay, then give up 230. You're in charge of everything. Go back to Stratton Oakmont. And I don't want that world. I don't think we should do that. But maybe that's sort of the solution to give them what they're asking for. I don't know that that's. It's not a good thing. I don't think it would be a constructive development. I think it would be better for the court to recognize that online speech belongs to the people who are speaking, not the platforms, but rather the users, and let doctrine develop from there.
Well, we're out of time, Matt. I will give you the last word. You've talked a bit about common carrier. Let's assume that NetChoice says the states can't do that. You've talked about antitrust as being an option you embrace, which is obviously something that you're probably more enthusiastic about than at least traditionally a lot of kind of conservatives and Federalist Society people. What else would you see as tools that might be available to deal with this first? And second, if you have any views on the NRA case and sort of the core case in the NRA of use of concepts like reputation risk, leaving aside sort of the bribe that was offered to the insurance companies, but the use of things like reputation risk in sort of regulatory concepts like that in this realm. You asked Alan the question about controlling the regulatory state, and I'll ask on behalf of Alan, how would you approach the question of controlling the regulatory state in a way such that it doesn't seem like they kind of overstep their bounds, but more generally, how would you think about solving this problem?
All right, I'm gonna write these down so I can remember them.
It's very complicated questions, don't I?
A lot of questions. So I want to say I think Alan, you made a really important point when you said people are just sort of acting like they're the only ones who are going to win elections, and that is a really, really, really bad situation. You have to be a society. You have to be able to operate under a leader from the other party, and you have to be able to accept the legitimacy of the policies that person or those people enact within reason, within the constitutional framework. And I think we have a really serious problem on both sides with that dynamic. I don't have an answer to that, but I just want to say I 100% agree with you. I think it's the level of paranoia on both sides make it really hard to have a conversation about fundamental legitimacy. I would say, like, I think one of the things that I think is really interesting about this series of cases is that it is doing something that I think is important, which is in order to have that legitimacy of a recognize we all live in a society, you have to be able to discuss important problems and address them, see some element of hope through our democratic institutions to address them. If you don't see any hope, then you're going to look for other means of addressing the core problems that you care about. So what I would say, I think one of the very serious problems that we have is we have overly expanded the First Amendment and overly expanded the Second Amendment, and we've constitutionalized a lot of the social questions or the prohibitions about social questions that we need to talk about. And if you tell liberals, there's nothing you can do about school shootings, just nothing you could do about it through our government, they're going to look for other ways to address it. And they're going to go through parastate institutions. And there's no way that you're going to stop that. And you shouldn't expect to. You should just say, there are social problems that we have to talk about. And a lot of I'm not going to get into constitutional interpretation, except to say that a lot of these interpretations are pretty arbitrary. And I will say that in terms of the First Amendment, the way that, the ACLU, for example, has tried to just bar constitutionally a whole series of legitimate questions about what we are as a society. For example, we can't really do anything about pornography that's just everywhere. It's just constitutionally barred. That's crazy. I mean, if you can't talk about these kinds of core problems, then people are just going to see less and less value in the political process in general. I mean, talking about the constitutional right of the Chinese government to speak in the US as they do with TikTok, a lot of the laws that states are passing around safe web design or what Florida and Texas are doing, this is all constitutionally barred. But from a lefty perspective, this is not new. Citizens United, or you can go back to the 1970s with elections and money and speech, and saying, the questions about corruption are not particularly important, or you really have to have traceability there, which is the same problem that you guys are talking about. If you overly expand these amendments, or there's the constitutional bar to all sorts of important questions, you will see people work through parastate institutions. It's just going to happen. So I think part of the question that we have to address is just where is it appropriate to just say all sorts of activity is stuff that we cannot touch through our political system, even if it's really important to do that. I think there's just a loss of legitimacy through that. I don't have an answer to that. I just would say, I think what's interesting about this set of cases is that if you really if you squint, they really are kind of walking back some of the principles of Citizens United, or thinking about walking back some of those principles. And we are recognizing that, yes, Section 230, which I think you would say, a lot of people would say, oh, that's just basic First Amendment principles. We're saying, no, actually, it's not. And so I think the sort of walking back some of these constitutional prohibitions is really important. And then the last thing is just, you gotta restore, you gotta break up the platforms, not just in terms of having multiple search engines or whatnot, but you have to restore the ability of private actors to finance themselves with a little bit of advertising. That has been a core part of the United States before it was the United States. Newspapers are older than the United States and they're dying. That's really bad, because it means like the advertising financed commentary and news is the kind of commentary and news that are shielded from the state because it's not financed by the state. And it allows to criticize the state and also to criticize other powerful actors. So in many ways, the consolidation of the flow of information is paired with the consolidation of the flow of advertising money. And if I were to say what's a good solution, it would be break up those concentrations so that you can just have more people causing trouble and talking, and they are shielded because they have a little bit of revenue, a little bit of a little bit of territory they can call themselves, they can make their own.
Interesting. Tucker Carlson has actually said that about his new network, about not being subject to the advertisers who pressured Fox. And I'll say one last word that was quite striking about your comments is at the same time you say they're talking about pulling back on Citizens United, the same people who are arguing that corporations don't have a right to speak are the same people who are saying the government does have the right to speak. So there's a bit of a interesting irony there, exactly, between
the traceability is now like
yeah, right. So we're in a very scrambled and fascinating time, and this was a fascinating discussion. So thank all of you for your time and for very thought-provoking conversation. Very free-ranging and well engaged. So, Alita, I will turn it back to you.
Thanks so much, Todd. And on behalf of the Federalist Society, I want to thank Todd and our panelists for a fascinating discussion. Thanks to our audience for joining and participating in the event. Please mark your calendars for the Freedom of Thought Conference scheduled for June 20th at the Mayflower, focusing on corporate rights and individual liberties. We welcome listener feedback by email at info@fedsoc.org. Thanks for joining us today. We are adjourned.